All right, thank you everybody for attending today. I appreciate that. We have with us Lisa Wawrzonek. Yep, I've been practicing. Thank you. Lisa is with ASAGA, and she is going to be talking to us about how to best deal with guardians when the residents you are trying to serve have a guardian, whether it be private or public. Some tips on how to best deal with them, what their role is, what their responsibilities are, and what rights the residents still retain, even though they have a guardian appointed to them. Lisa, why don't you share and take it from here? And okay. I didn't ask you, did you want to drive, or do you want to just give me the signal and I'll change slides?
But that's fine.
Okay, we'll go that way then. Okay, thank you.
All right, well, thank you for having me. As Catherine said, my name is Lisa Wawrzonek. I'm the administrator of ASAGA, which is the Alaska State Association for Guardianship and Advocacy. That is one little minor role that I have, and a much bigger role is a guardianship professional. Just a little bit about ASAGA so you know about us if you encounter family or friends, or even in your work that we can be helpful with. ASAGA actually started back in 1992 as a way of promoting excellence in guardianship, largely behind the scenes as far as guardianship reform, ensuring that we have good statutes, good protections. But it was just in July of 2016 that we actually start to reach out more into the community and helping families and others navigate the adult guardianship process. And that really came out of seeing a huge increase in public guardianship appointments. So the state of Alaska Office of Public Advocacy, a lot of confusion regarding access to the system. How do you start this, file a petition? A lack of monitoring, as we've seen those petitions, the number of guardianships grow. And really just sort of growth in the momentum of allowing people to make as many decisions as they can on their own. So the number of board members got back together, pulled me into it, and we got a phone and an email, and July 2016 started letting people know we were there to answer questions. So we are largely volunteer. We got lucky that we got a little bit of funding from the American Bar Endowment Opportunity Grant for the last couple of years. We are back to being unfunded unless the trust comes through with the funding request, which we understand is very favorable. But they, like many entities, are waiting on our state budget to make any major decisions for fiscal year 2020. But what we do is primarily, if people have questions about the system, about accessing, how to petition, how to fill out the annual report that they have to do, where to go for questions about benefit programs or other resources for vulnerable or disabled adults, we can help guide them. We're not attorneys, we don't give legal advice, we don't jump in cases, but when families have questions about the guardianship arena, we try to point them in the right direction. We have a lot of things on our website. We try to make it as easy as possible for people to look at things and view the trainings at their own leisure. We do a number of webinars. We do community presentations like this, and try to answer those basic guardianship types of questions. My main role for the past 19 years has been as a court visitor to investigate and review new or existing guardianships and report back to the court. I also have a long career, 15 years working with older individuals with the Alzheimer's Resource in Alaska, people who are aging or have an Alzheimer's or related dementia diagnosis. So my expertise is a bit more in the older adult field, but I've been doing this for 19 years now. I also administer the WINGS program, which is a interdisciplinary network of guardianship stakeholders to improve guardianship in our state. We've had that group going for about 2 years. And then I also work with the court system about guardianship compliance. So I am guardianship, guardianship, guardianship. What I'm here to talk to you about today is a little bit about the authority, what guardians can do, what they can't do. And I say, we're a fairly small group, so please ask me questions as we go. We can use the slides a little bit as a guide, but I'll make sure that we get through everything that Catherine has asked me to talk about today. I always like to start off by finding out, are there any burning questions? Did any of you have a situation that made you want to come today, or just kind of that burning question of, can a guardian do this? Or, what is a guardian? Does anybody have a question they want to make sure that I touch on today?
No?
Okay.
So I got, some people don't have the ability to speak, so they text.
Okay,
So I'll be keeping
you
an eye on that as well.
Perfect. All right. So when I gave this presentation at a conference recently, I wanted to start out with, this whole slide of keep calm and know your rights. Because I think one of the things that people don't realize, especially when they want to help a family member, an aging adult, disabled child turning 18, is that when you seek a guardian or conservator, you, in a sense, with that appointment, are taking away rights. So what are the rights that you have now, just sitting here on the table? What do you get to make decisions about yourself? What are some of the things that you can decide completely on your own?
What time I wake up in the morning.
Okay.
Where to live.
Where to live.
Driving my car.
Okay.
Finances.
Finances.
Spending money.
Yeah. What about those really small day-to-day choices? Like what you eat, what you wear,
If I take my medicine or not.
whether or not you go to the doctor, whether or not you pay your bills. These are all decisions that you can make. Now, there may be consequences, but the big difference there is that you have the ability to think through that decision, understand those consequences, and still make a choice whether or not to do it. I know that if I don't pay my taxes every year, at some point, it may be 10 years down the road, but at some point the IRS is going to say, hey, you, and they could attach my bank account. There are consequences to not doing that. If I don't go to the doctor and I don't have my labs regularly checked, I may not have known that I have high cholesterol and not gotten a medication for it and have consequences later on. There are a number of diagnoses that are out there that make it difficult for people to even control the basic of impulses. If I wanted that water, I would literally not be able to control myself from taking your water and drinking it, even though it's not mine, it's yours. But there are a lot of things that guardian and conservatorship actually take away much of what we just discussed. It's not just the big things. If you think of guardianship and conservatorship, they're called protective appointments. And in reality, they are meant to be somewhat protective. But sometimes it goes a bit too far into more of a control issue, and that's not the point of guardian and conservatorship. But I'm going to talk a little bit more what's in our statutes. But guardianship is never about control. It's about support. It's about advocacy. And at times, intervention if people need protection. But it's really not about taking over and being in charge of someone else. And there are a number of rights that people here in Alaska actually retain that in some states they don't. One of them is they have the right to vote here in Alaska, where, say, in the state of Arizona, they do not. Maybe voting is not important to that individual, but if it is, that's certainly something that you would want to retain the right of. Where people live is really important. What they get to eat or what they want to wear. But there's always a case-by-case situation, and where maybe somebody, all they want to eat is Snickers bars, but if they eat a bag of Snickers bars in one city, they're going to end up in the hospital and potentially in a diabetic coma and have significant health consequences. So maybe there is a restriction on being able to eat the entire bag, but we don't take all of the Snickers away. One of the scenarios that I will ask folks, and I always get a varied mix, I'm going to see what I have here, is it okay for someone to play video games all day long? What are your thoughts on that?
10-year-old says yes. I say, why not?
Okay.
Do you all agree? And folks online?
Any opposition where maybe that's not in their best interest?
May not be in their best interest, but it's their choice.
Okay. So, and there lies the really tricky part with guardian conservatorship is we all around this table, and raise your hand if you don't think you do, make decisions that are not in our best interest. Yes?
Oh, yeah.
Okay. I love butter popcorn. High cholesterol, shouldn't eat a whole lot of it. It's my go-to. Maybe should keep away a little bit, but we all make decisions that are not in our best interest. And so when we are appointed a guardian or conservator, there seems to become this ideal that we need to make all these decisions in someone's best interest. Now, is playing video games all day in our best interest? Likely not, but two case scenarios. One, there was and this was a review that I did several years ago, playing video games was not only in this person's best interest, it was detrimental to them. And the reason being is they had a very what's the word, easily triggered seizure disorder, that the concentration and looking at the screen with such intensity often would trigger not a small seizure, but a major one. And the doctor was like, they cannot play for several hours at a time, or else they're going to be in the hospital all the time. And after 6, they finally said, okay, we've got to stop this. But that individual, that person that was subject to that guardianship said, you're not taking this away from me, filed a petition for review, which he had the right to do. Now, the parents went out on this because it wasn't that they were taking it away, but they were limiting the time, because this was absolutely detrimental to health and safety. It wasn't just a best interest that, hey, go get a job or do something else. In another situation, I would have loved if this kid had played video games all day long, because when he wasn't focused on something like that, he was out getting into trouble and cycled in and out of the Department of Corrections. And if we could have gotten him to keep the Xbox instead of pawning it and then using the money to buy drugs, it would have been a better situation for him. So it really is very individualized. And so that's something to keep in mind. And I'm going to circle back to this as we get to the end. Yeah.
I'm just curious, in that case, was that a state-appointed guardianship, or was that the decision of the parents to kind of put a guardianship on their, sounds like their child?
In both of these situations, one was a family guardianship, the other one was a state-appointed guardian. And in reality, the type or person who was guardian didn't have much impact on those situations. It was really more of that particular decision, like, hey, we're going to restrict the amount of time you can play, versus, well, how many Xboxes can we afford to buy because he keeps pawning them. And like I said, we would have loved for him to play video games all day because it would have kept him out of trouble. We would have loved for him to have gotten a job through supported employment, but due to his particular diagnosis, there were limitations on what we were able to have in place for him. But if we could have, I would have bought his video games out of my own pocket if it kept him out of jail, because jail was not the right place for him. But the type of guardian didn't have much of an impact. It was really more of the decision making. So go ahead and next one. So, when you think about decision making, have any of you been in a position of having to make decisions for someone else? Okay. Any of you parents? Probably making a lot of decisions. Making decisions for someone else, sometimes it comes a little bit more easily, and maybe as a parent, you would make decisions differently than you would make for your aging parent if you had to be a power of attorney. When you're looking at making these decisions, it is difficult not to sort of project our own ideals, what we want for that person, or what we think is best for that person. When you become the guardian of an adult, the decision-making process becomes very much different than if you were to make decisions for a minor child. Because you really should be looking at how did that person make decisions when they could. It's not the time to say, I've always wanted my mom to get out and be more active, and now I'm going to help push her to do that, because if you're anything like my mom, you're going to hear some four-letter words when you try to say, hey, mom. Or in my case, I would love my mother to eat more salads, but she would prefer to eat other things and has told me where to stick my salad. But if I stop and think, I'm not eating salads every day. I don't have the same diagnoses that she has, but I'm not eating them every day. And so when we're talking about making decisions for someone else, we have to sort of check ourselves and ask time to time, are we making the decisions that they would have made that follow their lifestyle choices? Because it's not always about best interest. Sometimes it's substituted judgment. And that, again, is where the tricky part is, because if you're a family guardian, you love that person. You're fueled with emotion. If you're a public guardian, you have a little bit more of a separation, but yet now you're dealing with the liability if you make a bad decision. And that always weighs heavily on a private professional or public guardian. Not that it doesn't weigh on a family guardian as well, but there are some factors that may impact our decision making that we don't want to impact our decision making, but it's just a reality. Go ahead. The other piece that comes to sort of preface this before we get into the nitty-gritty is interpretation. All right, when we look at interpreting our statutes, one of the things I can tell you from all these different things that I do in guardianship, and I've worked in both courts across the state, is every court does things a little bit differently. They interpret even the laws that we would think our whole court system would do the same a little bit differently. One of the courts here in Alaska, if you file an emergency guardianship petition, you get an emergency hearing, no ifs, ands, or buts, regardless if it meets the statutory requirements. Because they interpret our statutes that if it's filed, we set it. Other courts will decide whether or not they feel it meets the statutes, and if they don't feel it does, they won't set an emergency hearing. And when we have that kind of inconsistency, it's difficult, and especially when it comes to how one court might interpret someone's decision-making versus another court. And because we all have different interpretations on how we view things, you know, Catherine may view something as an emergency where I don't. And we have a difference of interpretation of the situation. So interpretation really impacts decision-making as well. And I love that it's kind of small on these slides, I don't know if you can see it better, but the three main rules to interpret a statute, the literal, the golden, and the mischief. This is something that we do see as far as inconsistency, not so much mischief. I honestly don't know fully what that means, but the literal, which is the court who says you file an emergency petition, you get an emergency hearing, and the golden rule, which is sort of the ideal standard, they look at it differently. So let's look at what you absolutely cannot do as a guardian or conservator. That's in statute, it's in writing. And these are very small. I should have brought my glasses today, actually, so I'm going to have to peek behind me. Let's see if I can remember them all. So one of the things you cannot do here in the state of Alaska, this is not nationwide. These are things that vary from state to state. But you cannot place somebody into an alcohol or an involuntary alcohol treatment facility or involuntary mental health facility like Alaska Psychiatric Institute or the mental wings at either the Juneau Bartlett Hospital or at Fairbanks Memorial. So there are separate ex parte petitions if you want that to happen. You also can't consent to psychotropic meds. Those actually have to go through a hearing as well. And then if somebody has an alcohol issue, there's a separate ex parte for involuntary alcohol treatment. So as a guardian, you could not sign someone into these type of facilities without going through another process. You also cannot consent to an abortion, sterilization, psychosurgery, or removal of bodily organs without further court approval. We actually see this from time to time. There will be a request for tubal ligation, and it's not that a guardian can't, it's that in their order that they have it written, they need to come back and get court permission. The third one kind of goes in conjunction, and this is that you cannot consent to the withholding or removal of life support, again, without sort of the checks and balances of another person saying, no, I don't think this person will improve, and that would be the doctor overseeing the care. The reason being, in a nutshell, is the court doesn't want to grant one person or two people with their co-guardians the power to end a life like that without there being checks and balances. And that's certainly what an abortion would do. Sterilization would take away that ability to procreate. And then the withholding or removal of life support, we want some checks and balances. Some of you may be familiar of a big case in lower 48 many years ago, the Terry Schiavo case, where the parents and the husband were at odds of what they wanted to happen. We haven't had any real big news cases here, but certainly there have been times where these situations have come back to court where families want one thing, the doctor's saying another, or there are families disagreeing, and so it comes back to court for a ruling. So you can't do those things without further court permission. It doesn't mean it's not available, it's just you've got to come back and actually provide more evidence as opposed to just having that authority solely as a guardian. Next slide. Other things you can't consent to experimental procedures. A number of states across the lower 48 have this in there, and this really came out of the age of the institution, where people who didn't have family looking out for them were experimented on. And so you can't sign up someone for a trial of a new medication unless it's already gone through approvals, again, without court permission. You also can't consent to determination of parental rights. That's a separate procedure that someone would have to go through. You can't keep them from registering to vote or casting a ballot. If someone wants to vote and it's important to them, they can do that, even if they want to write Mickey Mouse in. It doesn't mean that you have to force someone to vote. It just means that they want to, they can. You also cannot keep them from taking and obtaining a driver's license, nor can you take it away. I have a number of parental guardians, child turning 18, and I get the same question, what's the point? They're never going to be able to drive. Well, they have to take the written test first. And wouldn't that be successful, or a success or great achievement if they were to study and actually pass that? Then they have to take the driving test, and maybe they won't pass that. It does not mean that you have to go buy them a car. All right, when I was 16, I passed my driver's test, and the second time, I didn't get a car. I mean, it doesn't mean that you now supply them with this, but it doesn't mean that you can't help them from trying to achieve any goals they may have. Then I get calls from the adult children of aging adults who are like, oh, my mom should not drive anymore. You can't take the driver's license away. Only the DMV can do that, and you can certainly fill out the form, as can their doctor, to say, hey, this person has very bad vision or an ongoing dementia, lots of confusion, they should not drive, and work with the DMV about doing that, but you yourself can't take it away. As a conservator, which is more about finances and property, you certainly could do something with the vehicle, and that's what a lot of people end up doing because they can't take away the license. But that is something that there is another process to go through to be able to take that away. Something we have here in Alaska that some states don't have, meaning that guardians can immediately take away licenses. Alaska is slightly progressive in our statutes in that they've not been overhauled in 30 plus years, but yet we adopted the Uniform Probate Act back in 1972, which actually we're getting ready to see about the renewal, that puts a lot of safeguards in place and a lot of what you might consider progressive views in that people can still vote here, where in many states they can't. They can't have a drive. I mean, some states won't allow you to drive if you have a guardian or conservator. So, and that's also true for the international community. So we do have some good things in place, and still a lot of work to do. You also cannot prohibit the marriage or divorce. And this scares a number of family guardians on both ends of the age spectrum because there are a lot of bad actors out there who may try to weasel their way into a situation if that person has property and sweep a person off their feet. Next thing you know, they're married and they want access to their money or their property. Or younger adults who want what their peers are getting and want to get married, but maybe don't know the difference between a healthy relationship and an unhealthy relationship. I've never had a case so far where someone's come to court to try and prevent someone getting married in my 19 years. So I don't know if that's ever been successful.
Because we stopped it.
Sorry. But it's not something that you can necessarily do as a guardian. But it certainly is a little bit of a concern because I have seen the cases where someone's gotten married and now have their benefits stopped because the combined income of two married individuals, they were now over-resourced. They lost benefits, the benefits that they really needed.
Lisa has a question. The guardian cannot prohibit a marriage or divorce, but can the reverse be true? Can they initiate a divorce against the wishes of their ward?
No.
Okay.
No. So if, and I've had a couple cases where, an individual, because of a brain injury or a dementia, is confused, they think their spouse is cheating on them, they want a divorce, and the guardian can't keep them from divorcing, and then the guardian can't, help them divorce. Now, if they want to divorce, the guardian can help act on their behalf and work with their attorney and, help make those types of decisions. And we certainly had guardianships where maybe they were a married couple and are now divorcing. And so the guardian, we need to bring in a substitute guardian because that would be a conflict to be divorcing your spouse or your partner and then also be their guardian making their decisions. And so we've had those situations where someone has come in. Sometimes it's just a matter of being able to advocate for someone who really isn't able to advocate for themselves for a fair divorce proceeding. But you can't initiate, you can't prohibit. Now, unless the person wants you to, and then you can help with that. So again, these are things that you absolutely cannot do without coming back to court. So when you think about what exactly is the purpose of guardianship and the purpose of conservatorship, just as a side note, guardianship is more about the person, the medical, the housing, the services. Conservatorship is more of the property and the financial, so the income, the expenses, your assets, your debt. When you have a full guardianship, that encompasses everything. And then you can have a limited or partial. You can have a limited partial guardian. You can have a limited partial conservator. Ideally, these orders would be written to meet the needs and not take away any rights that the person didn't need to have taken away. 20 years ago, in our state, it was primarily full guardianship or nothing. And this is the way it really was across the United States because we really weren't looking at limited or partial. The other problem with that is entities like Social Security or other benefit programs or even medical providers don't necessarily understand the legal orders and what they can and can't do. And so there's a lot of not honoring a particular order unless it says full guardianship. And that's the movement that we really need to project in our communities to help understand that, hey, you don't need a full guardian to do everything, but let's put the order specifically what they need. The last hindrance to that and why a lot of people push for full instead of a limited is access to get back in a timely manner when you absolutely need to. And courts across the United States are having difficulty with that due to volume. Here in Anchorage, we have about 50% or more of the volume of guardianship across the state, so it's a problem here. But if you file in, say, Dillingham, you could file one afternoon and get a hearing the next afternoon because their calendar is a bit more open. That itself can lend a difficulty because do we have all the information to make those decisions? So there's a few hindrances in why we are really still in that mode of full guardianship or nothing, or full guardianship or full conservatorship. But we're getting there with the inclusion of some alternatives, really getting better at writing limited orders. This is something that you're starting to see that movement forward. But the whole purpose is really to do what's needed and what's necessary, yet also promote independence and possible restoration of rights if possible. In fact, the authority statute, why don't you skip down conservatorship and the next one. Yeah. So this first statute that we have on a guardian authority is about your first rule, your first goal, what you must do is to promote the independence so they one day can come back and regain or restore rights, or at least participate in their life to the maximum extent possible. Again, this is their life. We only get one of them. So we really want to make sure that we're allowing that person as much freedom to make decisions that the best that they can. And if those decisions are significant, so with conservatorship, if assets are going to be wasted or dissipated. So let's give a couple of examples with money. One case that I worked on, there was a person who had a business. That business was losing money. Luckily, they had the resources to be able to do that without really negatively impacting their day-to-day life. They could still pay their bills. They could still do the things they needed to. They wanted to do this business. It gave them purpose in life. It was something they'd done for a very long time. The court essentially ruled that they could do that until it began impacting taking care of health, safety, and well-being, meaning if they couldn't pay to have food in front of them, if they couldn't pay to have a house over or a roof over their head, at that point, the business was no longer in their best interest. But until then, I mean, think about it. We all have hobbies that we do that we might pay money to that we don't necessarily get something financial back. And so this is the way that the court looked at that. And when it became detrimental to that, then that decision was reversed. Maybe you have, your dad really loves to play poker, an example that was given today. And when he goes, he's a really bad poker player. He loses his $20 every time. That doesn't mean that he doesn't get some satisfaction or enjoyment out of that, but is it detrimental in the long term? So when you look at decisions in that way, that is it in their best interest? Maybe not to lose money in a business, but yet is it detrimental to health, safety, and well-being? It might not be there yet. Back to the Snickers bar, and one Snickers bar probably isn't going to do much, but 10 might. And especially if somebody has a diagnosis like diabetes or something else that would cause them to really have medical issues, or even the video game scenario of, will this trigger a seizure? Is eating a bunch of Snicker bars in their best interest? Probably not, but is it detrimental yet? There's a gray area in there. And how we interpret, and this is the piece where you want to, again, check yourselves on, are we projecting our own ideals when we're making those decisions? But our first statute is we want to allow them as much independence as possible. So how can we support their decisions? How many of you have heard of the new legislation, supported decision-making agreement? Has anyone heard of those? Okay, a couple. So the idea behind that is, in a nutshell, we all need support when we make decisions. I know nothing about plumbing, so I'm going to call a plumber and I'm going to listen to their advice. I know nothing about financial planning. It's why I have a financial planner to help me save money for when I need it in retirement. We all look to others, whether it's a formal support or an informal support or a sounding board to make decisions. And that's the idea behind a supported decision-making agreement, is that we can put in place people who have access to information about us to help us make decisions, but we still make them. This is really something that can be done within a guardianship, and in fact our legislation here has built it to where we can have these agreements within a guardian or conservatorship order. But even without them, an ideal guardian is going to ask the person what it is that they want so they can support that decision, so long as it's not harmful to self or others. In fact, the National Guardianship Standards of Practice, which Alaska has adopted, which are those ideal standards, say the first rule of decision making is ask the person what they want. It's so simple, but how often does it happen? And it doesn't happen sometimes because people are often really, really busy doing a lot of stuff. There's a sandwich generation where you have adult children taking care of their own children, yet also taking care of aging parents, and trying to get dinner on the table, trying to work, trying to make sure that the Medicaid applications are done, or Medicare reviews, or other paperwork they might need in addition to all their own lives. They might say, I know what mom needs, I'm just going to take care of it, without going to mom and saying, is this what you want? There are certain situations that people aren't going to understand those questions. So then you go down the line of how can you help them decide what they want? How can you use their lifestyle choices to make those decisions? And then ultimately you're making them in their best interest. The reason that this statute's first is because of this next one, which is essentially a full guardian. Oh, no, go back. Sorry, it's just the next. Nope. One. Down two. There you go. Okay. So there's A and then C, which is that you essentially have all the authority that you would have over a minor child. So for those of you who've been parents, and think about all the decisions that you actually legally can make for your children. You decide when they get up. Now, they may give you a hard time about that, but you still make that decision. You decide where they'll go to school. You decide what they'll eat. You decide if they turn 16, if they can get their permit or their driver's license. You have a lot of big to small spectrum decisions that you can make as a parent that you now have the authority for an adult for, and that's a lot of authority. So when we train guardians, we ask them to really think about that, because these are all rights that are taken away. So does someone have the right in a full guardianship to decide where they live? No. Lost that right. Full guardianship includes housing, which means you've lost that right to make that decision. Ideally, I should say, if I'm your guardian, where would you like to live? And if you want to live in a place that seems reasonable, if you tell me you want to live on the moon, then I might become creative and paint your room black with a bunch of glow-in-the-dark stars. But obviously, I know that's not reasonable. If somebody really wants to live in their own home, you want to go through all those things that can help them be there with reasonable safety and well-being. And that, again, goes back to interpretation. Because you might interpret that this is reasonable and it's acceptable, where you say, and APS says something different, and the judge says something different, because we're all interpreting situations differently. Sometimes it's based on our knowledge, sometimes it's based on our own thought process or interpretation or perspective. But you've lost the right to decide where you live. You've lost the right to decide whether or not you have a job or where you work. But when I go out and I talk to providers, they're often like, no, they can decide if they work or not. They can. They can basically say, I don't want to be here anymore. And if I walk out the door, they can say, I'm not going to the doctor, put their feet down, and not go. Having an order, a piece of paper that says, I make your medical decisions, does not necessarily make being a guardian or conservator any easier for you. Because people still have free will, even with that court order. But the right is taken away. Does that make sense? Sort of this distinguishing factor. If I'm Catherine's guardian and I say, we're going to go to the doctor, and she says no, I can't physically force her without getting what we call a writ of assistance, meaning that I can call APD and APD will force her to go. But you're not going to get that unless it's really, really detrimental. If it's like, oh, well, I really just want you to have a checkup, they're not going to do that. It's in her best interest, and I might try a variety of strategies. You might even call it, bargaining, or what's that other word that we're not supposed to use?
Bribing.
Bribing, yeah. The one thing we don't want to do is we don't want to punish. So let's say someone will go to the doctor, and then I say, well, fine, I'm not giving you any spending money. That's not dignified with being an adult. Right? You decide what you spend your money on. But maybe I'll say, you know what? If you go to the doctor, I'll give you a little more money if you can. Or we can, I'll try to get you this thing that you want to do. It's a lot of strategizing of how you know that person. If I'll take my mother, for example, she's stubborn as a mule. And I kept saying, Mom, put your advanced directives in place. I want to know what you need. I don't want to just all of a sudden something would happen and not know what you want. No, we don't need to do that. We don't need to do that. I'm like, oh. So I realized that my mother doesn't like to be, she fears being a burden to her kids, and she likes to come things to her own way. And so I said to my husband, we're putting ours in place. And this is when we are in our 30s. He's like, we're only in our 30s. What do we need them for? I'm like, well, anything can happen at any time. But I'm doing this as a back door, because if I do it, so I go and we put our things in place. And I say, Mom, we put these in place. Here you go. We don't want to be a burden on you. We really want you to know what we need or want if this ever happens. And I don't want to burden you, She's like, oh, thank you. Next day, she and my dad were calling up the attorney. We can't be a burden on our kids either. I'm like, thank you. So figure out what works with that person instead of just saying, I've got this court order and you're going to do what I want. I had a young man in the Glen Allen area who lived in a dry cabin, was able to live on his own. He had a caregiver that came in every day to check in on him, get him groceries, help out with things, but he hated to bathe. And we don't know what brought that on. Maybe it was because he had to go across the street to where they had the bathrooms and the showers at the local grocery store. Whatever it was, he didn't want to. Now, we don't have to take a bath every single day. In fact, they often say older adults shouldn't because they have dry skin and but we need to, of course, keep up hygiene to prevent infection and other things. And that's what would happen is he would get some dry spots, scratch at them, they get infected, and keeping his hygiene just, once every couple of weeks was in his best interest. The guardian can't force him to go take a bath. But what the guardian did is said, hey, every time I get a call from your caregiver, I'm going to, the $25 I send you on Monday, I'm going to send 30 or 35. And so he made the decision, I don't need that money. I'm not doing it. I'm not doing it. And he was pretty, and I did his reviews for several years. I'm on his call list. So I just get a random phone call sometimes. And sometimes I get the random phone call as a court visitor. Hey, I took a bath today. I'm like, all right. He's like, when you get that $35, right? I'm like, I'm sure you will. If you don't, you let me know because then I need to call your guardian. If the guardian's to your word, does it. So, but when he doesn't want to do it, he won't do it. So we have free will. This piece of paper doesn't do anything for you. But you have to find ways to try and help people come to their decisions, but allow them the ability to participate in that process. Now, I am guardian for one person who is not a family member. I'm a volunteer guardian. I really felt it was important in my role to see what it meant to be a guardian. And she is nonverbal, very disabled, fully dependent on others for even the basic activities of daily living. She cannot participate to me in a real meaningful manner when I make good decisions, like when the dentist was suggesting that her teeth be removed, because she made the decision she didn't want her teeth brushed. They try to get in there, and I would go over and I'd say, okay, let me see it, and she just wasn't having it. If she doesn't want to eat something, she pushes it away. So she's making some of those small day-to-day, and we recognize that, but big things I can't really talk to her about. And so what I do is I look at all the other factors. I look at her culture and how and I talk to people from her tribe and say, what would you guys do in this situation? I look at her caregivers with her every single day about the things that she does. So I know that all of you go out to assisted living homes and sort of help monitor the quality of the care and whatnot. And so those are things that when you are out there, you know, those are the people that really know their day-to-day habits and are good resources when guardians start to make decisions about somebody. And there should be, you know, a table doesn't stand up very well on one leg. It stands up better when it has more support. And that's kind of the same concept of looking at all those different resources. Because when you look at these two statutes, they're almost in conflict with one another. You have all this authority, make all these decisions, but yet make them using, you know, these parameters and maximizing independence. So I mentioned the guardianship standards of practice. This is, and I have this document if anyone is interested, it's on our website. But these are those ideal standards looking at a variety of different things that you might, when you're making decisions. There's a standard about decision making, which again is ask the person what they want and go from there. But there are standards about working with providers, working with other family members or friends, the whole idea of right to association. Is anyone familiar with the Casey Kasem family drama seen on the news where basically there was family that wouldn't let other family see him and they thought, you know, basically isolation. There's a Peter Falk also had the same situation. You know, when we talk about the right to association, there's actually some new language in the Uniform Probate Law that says, as a guardian, you shouldn't have that without really just cause. So if you're going to not allow someone to see that person who that person wants to see, you have to have a really good reason. They have to be detrimental. They have to cause some level of harm. And so, yeah, go ahead.
I was just going to say, we have an active case right now on that very issue, right, Mary?
Yeah.
And we were a little appalled because we didn't realize the new standard of a power of attorney actually lists in their personal relationships.
Mm-hmm.
And this power of attorney has said he will not see this friend.
Mm-hmm.
And so we've been called in to say, well, that's against his rights. He's got rights to have visitors of his choice.
Yeah.
So we're in the middle of that issue right now.
Yeah. And that can get really complicated. I mean, I had a particular case where the family member that this person had made, the power of attorney, trustee, inheritance, everything. Doctors and lawyers did all that years ago. Now has dementia. And according to the one family member, you know, it doesn't want to see these other family members. Never did.
I wonder if this is the same case.
Might be.
I think it is.
Now he doesn't remember.
Yeah.
And wants to see. So
The turning point for us was it is power of attorney. This is the second POA that he signed for her. The first one was like decades ago. So that made us feel that this person.
different case.
Different case? Okay.
Different gender, yeah.
Okay.
So, but that becomes very, very complicated because who, you know, I wasn't with them 10 years ago when all this was put in place. I'm really going off of what this person had documented before. But, and it's difficult when you're a guardian trying to advocate for what you think that person wanted when they made those decisions, but now they're making different decisions. I've had people put in place, they don't want nutrition or hydration, they don't want all of those life-saving measures, they just want to be comfort care. Then get wheeled in the hospital, don't let me die, do everything. Like, what do you do there? So those can get really, really difficult. But the thing that the standards tries to do is provide some framework of what you should be thinking about when you're trying to make these difficult decisions. One of them, and I think we're going to see more and more of this, is even sexual relations. You know, there are long-term care facilities across the United States that have policies in place that two people cannot get together. And that connection is a basic human right. So how do you say that they can't? The flip side is, how can they give consent? And those things are often, you know, in dueling with one another. But it's kind of, in some ways, things that capacity doesn't throw a blanket over us that we have full capacity or no capacity. There could be some things that we understand very well and can make decent decisions, where other things, because of the diagnosis, might impact us. There are also things that are somewhat ingrained in us. In fact, they say that the area of our brain that drives sexual desire isn't affected by dementia. And so if that's not affected and people still have the will and the want, and they want to engage, can we say that they actually understand and, have consent? Other arguments have been, well, they don't understand or use protection anymore. I mean, so there's lots of different arguments, and these things get really, really complicated. But these standards try to put things in a framework to help those decisions be made. And one of them, a big thing, is to have some of those difficult conversations with people that maybe make us uncomfortable. But it becomes our role when we get into that decision-making arena. If we're going to make the decisions, we need to know.
Can you shed some light, in that same case I was talking about, the new approved power of attorney form also has as one of the powers the POA can have, is to change previously determined beneficiaries. So a person makes their will or whatever they made 15 years ago, and now their POA can change. We don't quite understand why that's even there.
I couldn't tell you. I'm not an attorney.
Yeah, right.
There are certain things that even a guardian can't change. A guardian cannot change a will. So,
But could they change a beneficiary?
But they can change a beneficiary, and that's happened because and people have asked for their beneficiaries to be changed. In fact, I was just in court the other day where, the guardian actually has 3 people listed, and the person has said in court, I don't want that person and that person. And
Because something has changed in the relationship with that person? But
they haven't seen any of these 3 people at all, period. I mean, they've not been in their life for a very long time. And so why they're making this decision, I don't know.
That just raised red flags with us, that if someone puts all their documents in place and they take the time to sit down and make designees,
Yeah.
then it can be changed at the desire of the POA, but hopefully there's just cause to do that.
Yeah, I mean, I think, I don't know as much about the legality of why with the new power of attorney, because I'm not an attorney. And why certain, you can't change a will, but you can change the beneficiaries. I mean, why?
Yeah.
Why is that designation there? So, that, and honestly, that gets really into the, we have a new statute committee that's recently been formed that's going to start taking a look at our guardianship statutes, because Alaska is one of those states that's not been had a reform in 30 plus years. Now, we've had a few tweaks and changes, but not a major overhaul. Yeah.
I'm curious, so the Advanced Health Directive usually includes a power of attorney. So does that automatically update to this new version of power of attorney? Because, like in my case, I have a will in place, but I also have an Advanced Healthcare Directive. So if I get an accident, that Advanced Directive goes into place, does everything else potentially go out the door? Because, wow.
Well, here's my favorite answer. It depends. I've had cases where things have been put in place and then people question and contest them that they should be different, and yes, I've seen the things that people put in place go away, and I don't necessarily agree that it's fair, but I've seen it happen, and I've seen other times where it's upheld. The thing about an advanced healthcare directive is that can be built into a guardianship. So if you have an advanced healthcare directive about what you want prior to guardianship, the guardian can use that. In fact, the reports in the forms actually ask if that's there, or if someone is a DNR or do not resuscitate versus a full code. So when those things are already in place, you don't want to take those away. You want to have the guardianship or the guardian use that information to make those decisions. But if you have, your will and your power of attorney, and you have 3 kids and 2 of them are, nope, we want to follow this, and the third one says, nope, I think he wanted something else, well, they can bring it to court.
But just because the power of attorney was on the previous form doesn't invalidate it or void it in any way.
No,
so it would still be effective, it would still be in place, it's still good.
Yeah.
This might be a litigating issue.
Well, the difference is that in the old power of attorney form, they wanted you to cross out powers that you didn't want and initial it. The new one says just check the ones you want.
Right.
So it's a different way of looking at it, but it doesn't mean that your version is false.
So mine is the new one. Does that
that's very cool.
Difference.
Yeah, you should be cool.
Yeah.
When we talk with families, especially about alternatives, and why don't we go ahead and go to that slide? When we talk about alternatives, to put things in place now. I mentioned my husband and I did ours in our late 30s, which appalled him because we were so young. But the truth is I get guardianship cases for people 18 and over, and some of them are not because of a disability. It's from a car accident and a head injury or a snow machine injury, and so when you have these things in place, so that family members know what it is that you want, that's always ideal. It doesn't mean that they'll necessarily agree or follow your wishes. But what we tell families is put these in place and we visit them from time to time and have those family meetings so people do know what it is that you want. It makes it a little bit harder when you've reiterated it, when you have full capacity that this is what I want, feel very strongly about this, versus just having it in place and not talking to anyone about it. My family is a prime example. My brother and I unfortunately do not get along. He's got very different ideals than I do, and we are not two people that are going to be able to come together. In fact, to the point that I've asked my parents, I'm their executor, I'm their power of attorney, I'm all of their things, because they don't trust him to actually step up when need be, and they also don't agree with his ideals. But I also know that he would more than be happy to challenge me in court. So we actually have a third party that, although I'm the executor, we will use the third party. So I'm not having to deal with him if anything were to happen. It all goes through the third party. And then, of course, it would go to court whenever needed, action it needed to. So it's important to try and get that information out to your families and choose someone that you trust to have these things in place. But the unfortunate thing is it reduces your risk of ever having to have guardian or conservatorship, and it doesn't necessarily take the risk away, unfortunately.
I'm just curious. I've sadly gone through 3 estates, but both my sisters, both my parents, actually 4. So in your case of having that third party trustor or trustee, I always get those mixed up. Is that a co, or are you actually just turning it over to him to?
I am still the authority,
Okay.
but someone else is doing all the work. So I would still make any decisions based on my parents' wishes, but they are doing the work. And what it does is it creates a buffer between me and my sibling. So if he has issues, he goes to that person, and that person then, because I'm following my parents' directive, is also essentially agreeing that I'm following the directive. Basically, they're the person that says that I have not taken, whatever they had left and spent it all. Here it is, and here's your split. Like, they're corroborating what it is that we're doing at P&B and providing that buffer. But I am still, we could do it that way, but we have absolutely no idea if the person we put in place now is going to be around. And so we've just set it up to where this is the person we're going to use. You've got all the documents, should something happen, and then if that person retires or goes away, I can take all that to someone else.
Yeah.
But when we talk about alternatives, power of attorney is certainly one of the things. And here in Alaska, we have 2. We have both the healthcare and also the financial now. Alaska Legal Services is generally really good about keeping the most up-to-date forms on their website. So if you're interested in doing your own, they have the most recent version on their website. We also have the new supported decision-making agreements. And so you may start to hear that when you're going out to visit assisted living homes. They may not have guardian or conservators. They may have a supported decision maker rather than a guardian or conservator or power of attorney. It's not that all these things are just alternatives to one another or it's one or the other. Some of these things can be used in conjunction.
Can you have a court-appointed guardian that was previously determined modified to include supportive agreements?
Yes.
So that's something that we might, because we hear a lot of times in the facilities with the residents saying, I have a guardianship, but I can still make some of my own decisions, but they're not letting me.
Alaska is unique in the SDMA. Wow, it's 1 o'clock already.
Yeah, and I'll just pause. Folks, if you need to leave, go ahead, but we're going to carry on as long as there's people here that have questions.
I am pretty much wrapping up, but the hour goes by fast. Alaska is the only state that I'm aware of that has built in its legislation for supported decision-making agreements to be used within a guardianship. So if you have someone who really does need a guardian for a number of issues, but they feel really strongly about this one, you could build in that supported decision-making agreement. Now, you could also simply put that in a court order. It's not like you didn't have that ability to have a court order that says this person will not be moved from this particular home without further court order, or this person you won't sell their home without further court order. But it allows for, especially newer guardianships being determined, if you're mediating something, you can build in a supported decision-making agreement. You could also have an SDMA and a power of attorney. You can have a power of attorney for medical, but a conservatorship for financial, because financial POA wasn't working for some reason.
If someone wanted to add the supported decision-making, would it just be a guardianship review petition that they would file?
I think so. This legislation is so
Okay,
new.
yeah.
If you did not have a guardian in place, there's a process that you go through to do a supported decision-making agreement. I think probably if there's a guardianship in place already, it would likely be a petition for review because it could simply just be mediated and then referred to the supported decision-making process.
Are the courts then considering the supported decision-making at the level of petition now from all going forward? Is that automatically discussed?
It depends.
Okay.
It depends on the court and the court's understanding, and there needs to be judicial education. So they will get there. We've not even had this for a year, but that's on the docket of essentially getting that out to people. And there are new court visitor reports that soon will be out that the visitors must use. Right now, anyone can use their own format that will say what alternatives did you investigate that are either not working because they're in place or they're simply not feasible to put in place.
When we're talking to our families, though, and they're contemplating filing for guardianship, we can at least propose that they discuss this and maybe explore whether or not that'd be a good option for them and include it from the get-go with these petitions.
So our website has these helpful links, and one of the helpful links is to the Governor's Council on Disabilities website that has information on if you're a family member and thinking about supported decision making, click here. If you're a provider and want to know more, click here. If you're a judicial officer or a court employee, click here. And it's tailored to meet the needs of the audience that's there. And then we will have up on our ASAGA website sort of a where do you start, or is guardianship for me. We're just finishing that up, and that'll be narrated where people can look at it all, but it'll be going over all of these options and where you can get more information, because it's kind of all over the place. For example, Alaska Legal Services has a great narrative PowerPoint on powers of attorney. So if you want to learn more about those, we want you to know where to get that information, or supported decision-making agreements. And again, these things they can be used in conjunction with one another. It's not one and nothing else. Just like it's no longer full guardianship or nothing. It's not just an SBMA or just a power of attorney or just a guardianship. These things can be built to meet the needs of the person, and that's ideally how it should be. You may start out with a medical power of attorney and a conservator because the financial power of attorney, there may have been exploitation, there may have been a lack of understanding, or maybe they have benefits that won't honor a power of attorney. Some governmental benefits or pensions don't want to honor powers of attorney, and they want a court order. Social Security does not honor powers of attorney. In fact, because they're federal, they don't have to honor guardianship orders either. But they do for the most part, but they will make you jump through that extra hoop of becoming the rep payee for them. So you may have to come up with, these are all tools, essentially. You use a hammer and a nail, but you can also use something really hard and find another tool to accomplish the same thing. And so it's using these things as tools. And then just to kind of, again, to wrap up, and I mentioned, be mindful of that double standard. And this link no longer works, but it's a great video if you ever seen her. She's this little girl, and she's basically talking about children versus adults, and it's a lot of like, I don't understand why I got in trouble for using my mommy's cream. My mommy puts it on her face, and she looks beautiful. All I wanted was to be beautiful like my mommy, and that's why I used her cream. Now, when you see the video, she's got this thing like smothered. But it's a great representation of, I want my mom to eat more salads, but I probably need to eat more of myself. And so to be real careful about projecting our own ideals. And the thing is especially the folks that you visit, they may have a guardian or power of attorney. They've got their assisted living home caregivers. They may have a care coordinator or a case manager. They may have other family members. Now they've got you guys coming in. They've got a lot of people potentially telling them how to live their life. And so, if there's one thing that we can be mindful is making sure that their voice is being heard if they're able to provide it. You'll see a number of people that aren't able to, and then you're looking at lots of other factors. But for the people that can, we want to be mindful that we're allowing them to do that.
And before too much more time passes, I would like to talk briefly about the volunteer who is trying to advocate for the resident who has a guardian most likely a public guardian,
Yeah.
And has a really difficult time communicating with them. Any tips on how to make that go?
So, the Office of Public Advocacy, our public guardian's office, has unfortunately, due to budget for the most part, about 80 to 100 cases per person. So you're talking about the management of medical, housing, services, and financial, and with all of the bureaucratic stuff that comes along with all those things. For example, I am the payee for one person. It took me 9 months to get Social Security just to change from a public guardian to me as a payee. 9 months to literally go into their system and put my information instead of the public guardian's information. So that really bogs a lot of stuff down for them, and unfortunately it's putting out a lot of fires. I can't say that it's necessarily the OPA or the Office of Public Advocacy, it's their fault. I mean, it's really a state of Alaska thing. As far as communicating with them, I do know that when we talk to them about getting communication, one of the things is emails easier, putting in the subject matter a brief description of, assisted living issue response needed versus, hey, this is an FYI, we wanted to let you know. Because that will kind of trigger like, hey, I really need to read that and see if I should respond versus, we went to the doctor today, everything's fine, just letting you know, FYI. Also, if you're not getting a response and you feel it's necessary, to CC their supervisor. And it's not always that she will get back to you, but she may poke her head and go, hey, get back to this person.
Is Beth still over there?
Beth is the deputy director now.
Okay.
Seer Polta is one of the supervisors, but right now they're still trying to hire, I think, for Beth's supervisory position. She's been promoted.
She's still involved though?
Yes. Yes.
Okay, and Steve is still there.
Steve. Yes.
Young.
Steve Young, yeah. So Steve and Beth would be two people I would CC on any emails like that to public guardians. Certainly there is always the right to petition for review if it's really bad. Anyone can do that, including the person themselves. So if you have an individual who is somewhat capable, there's nothing wrong with helping them write a letter and having them sign it though, but make sure it's them. If it's you, you need to sign it. If it's them and you're just helping them with that, then they need to sign it, and that can go to the court because they can always request
And to
that.
clarify, we as an office will never be the one petitioning
Okay.
ever. So don't even go there.
Yeah.
Because we have to advocate for the wishes of the residents,
Right.
and so we couldn't do
But
that.
you can advocate to let them know they have the right to
Yes.
request a review.
Oh, we can help them. I'm all about
Absolutely, yeah.
that, support them in what they want to do.
I've had over the years, not a lot, but every once in a while, a provider who will help someone fill out the petition. But that person has no idea what they're filling out, but they still sign it. And the minute you go in and say, hey, you filled this out, you would like a guardian, I don't know what that is, boom, that goes away. Because if they don't know what it is they've done, and really it's been the provider that should have probably signed it because it's in their writing, it's all of their information, but they have the other person sign it. But they do have a right to request a review at any time, and respondent reviews carry a lot of weight with the magistrates. Now, if they ask for review every single month, at some point they're going to decline the review because they have to show that something's changed. And we get a lot of respondents who petition because they're mad at their guardian for some reason, but it's the same thing that they're mad about, and it's just a circle that they're doing. But if they really have a significant issue, the court can appoint a visitor to go out and just check in on things, or they can set a full review hearing where they'll have an attorney appointed and time to go back to the court. But the individual has the right to request that review at any time. My last slide before the informational slide is really just about that tug of war, kind of circling back to the idea of ideals and interpretation. Because like I mentioned, if you were seeing someone in an assisted living home, you've got a number of other people that may also be involved and have different perspectives. And so communication is really key to do that as a team. The guardian should be a part of that. And I make no excuses for the public guardians other than it's really difficult to manage 80 to 100 cases per person. But if you are truly seeing something that needs to really be visited, I would encourage those reviews. You can certainly do confidential reports of harm to APS, I assume, which might just circle around back to you. But if it's financial in nature and you have concerns about that, there's the Office of Elder Fraud. So there are some recourses, and sometimes it's just being this huge deal. But there is often sometimes just that tug of war between people's perspective, their perception, their interpretation, and what they think is in that person's best interest. But ultimately, we want to make sure that person has a voice if they're able to tell us what it is they want.
I've had 2 cases, just in less than a year where the guardian quit. Said, I don't want to do this anymore. And kind of walked away.
Is that a state appointed guardian or family guardian?
It was,
Or court?
they were private.
Family,
They were both friends.
And
It's tough sometimes.
And
Yeah.
that is an issue. Personally, I think we need other alternatives to the public guardians. I like people like myself who are willing to be volunteer guardians. There are some states that's all they have is a volunteer guardianship organization. They have someone handling finances that's professional, but the guardians are actual volunteers. Because we can't keep giving people to the public guardian's office, they're not going to be able to accomplish anything. At the same time, though, a lot of individuals quit because the court is doing more of enforcing what it is they should, and people find that difficult. Also, people quit because the individual themselves, due to their disability or diagnosis, may not always be the nicest of people. There's all sorts of reasons why people would not
It's
continue.
not paid, right?
It's not without court permission.
Right.
There, you can't come back if the person is able to get a small stipend, but it has to be in the court order. Because it's a conflict to be financially, to gain financially from being a guardian unless it's alleviated by being in a court order. So the public guardian and private professionals can get paid for their fees, can get their fees paid. But if it's a family or a friend, I've had a couple come back where it's like, I drive them to all their doctor's appointments and they are asking for $50 in gas. There's things like that that can be done to help compensate. But compensate for everything that needs to be done, sometimes people don't have the money to be able to do that. So we really need to look at supporting our non-professional, non-paid guardians. But we also need to make sure they know what it is that they're walking into, because it can be a difficult job, and the court has the responsibility of enforcing and monitoring to ensure that they do that. That's my role here at the Anchorage Court as the compliance manager, is to make sure that guardians do what they're supposed to. And I can be as nice as possible to help them understand and handhold and sit down with them and go over everything. And then I can also become confrontational if need be, if they are mismanaging or stealing or letting Medicaid lapse or not doing their role. And it's it's a regular balancing act. But I do think we as a community, as a state, need to do more to support them, because if you go in knowing nothing about Social Security, how are you to manage Social Security benefits? If you go in knowing nothing about a trust, you might mess up that trust and not mean to. If you don't understand the framework of decision making, you may revert to how you know to make decisions, which might be how you made them for your minor child, which is, again, not the same way you make them as an adult. So and better education and support, I think, is needed, especially as we see this population grow.
Well, I was a power of attorney for my ex-in-laws, and the bank did not want to honor that power of attorney.
There are banks who have policies that if you have a guardian, you can't have your own account, and that is not true here in
I know,
Alaska.
they're really conservative.
Yeah,
I thought we only had a couple of banks that would have guardianship accounts.
Well,
Has that changed since?
it's not so much guardianship accounts. Most banks will do like a joint kind of guardianship account. There are some that don't understand it at all. But there are a couple of banks that, so let's say I have a guardian, but yet I am capable of using a debit card and spending my allowance money how I want to. There are banks that will say, you have a guardian, you can't have your own account. So it might be in the guardian's name, but it's an account that I'm using. But you can have there's nothing in our statutes that say people under a guardian or conservatorship cannot have their own account. Now, if they can't manage it, then obviously someone would need to step in. But if they can, which some people do successfully, I don't know where the banks have gotten that.
Actually, there's a program, I can't remember what it's called, I got information.
TrueLink.
Thank you, I was going to say,
Yes.
there's TrueLink, which they can have their own thing, but
And
can manage it.
It's not an account, it's a debit card that you upload to from an account. So the guardian could have the guardianship account upload to TrueLink, and they can
Beautiful
swipe
thing.
away. And it's a great resource.
Makes them still feel like they have independence and
Yeah.
choice.
They
But
don't
yet
get their
there's some
software.
parameters.
But the guardian can also get alerts when they're using it, and they can know, if you have a serious Joanne Fabric addiction, the guardian can even say, you can only spend $20 at Joanne Fabric.
Is there an intervention that that, because
Yeah.
there's a family member of mine I'm thinking about.
So you can tailor it to meet the needs of any problems that they might get into, but yet still allow them that independence and allow you to monitor.
What amazes me in this field is the number of CIRs, critical incident reports that we receive that like an administrator that's in place. Like so-and-so fell for the third time this week. What can be changed? Get them a guardian. Well, what the heck do they think that's going to do? You know, I don't understand. You know,
I think some of that comes from people, there are times that I see petitions that the team is uncomfortable in allowing that person to make, I mean, they want that extra backup in a sense that this person is making the right decisions for themselves. And I've seen that where, you know, a lot of providers will say they really need a guardian. It's not so much that they need a guardian, it's just that people are looking out for liability. So, and that's somewhat unfortunate. What we can do better with those situations, especially when there's no family, you know, is really look at limited orders, because they don't need a guardian for everything, but they might need some backup on this one particular situation. And especially when they're, you know, what's the definition of insanity? Doing the same thing over and expecting a different result. And so there are things that are happening over and over and over again that make people nervous if there's not some type of intervention. And this is the go-to intervention, unfortunately.
Yeah. Any questions? There's 3 folks who hung with us online.
Okay.
Thank you, people online. You're real troopers. Any questions out there or in the room?
And my contact information is on that last slide. Please feel free to call or email if you do have questions. You're welcome to refer families or even respondents, people in an order or subject to one, if they have questions. I often, you know, not as much as the families, but I will probably once or twice a month get a call from someone who wants a review or wants their guardianship looked at, and I can explain to them what they need to do.
So we have had a couple of instances where an adult child has an unlimited durable power of attorney. And the question comes up as to whether or not they should file for guardianship. Is there any benefit to being a guardian as opposed to?
If it's not broke, no.
Exactly. That's
If
kind of my
someone's
thought.
not honoring it, or it's
If it's a social security issue,
yeah,
or
then
if
they
it's a
might
bank
need to
issue.
come in. They can still keep that, but yet get a specific order for what the problem is.
Okay.
But the problem is that people say, oh, they're not honoring my power of attorney, I'll just get full guardianship because it's a court order, everyone will honor that. But a power of attorney is a less restrictive alternative.
And in theory, if it's unlimited, all the powers are checked, and it's durable, then it should not be weighed any heavier than a guardianship.
It is a private agreement between 2 people that gives you the same authority you would have in a guardianship other than it's given to you by the court.
You heard it over there too.
I did.
So, but it just, I mean, you know, if it's being honored and it's being used correctly, because a lot of times we have petitions because a power of attorney is not being used correctly.
Right.
It's being,
Oh, I have no problem with
you
that.
know, being abused in some way, or we have powers of attorney that the power of attorney isn't doing anything.
Or they're exploited. Or
Yeah,
they're,
yeah. So, but yeah, I hate those petitions. Oh, my care coordinator told me to file. What's wrong with your power of attorney? I don't know.
Yeah.
And now they pay the filing fee, and they're real mad when you say you've got something in
And
place
you're
already.
bottlenecking the court system because there's these frivolous petitions.
Unless there's a problem, you know, it's the old adage, if it's not broke, you don't need to fix it.
Awesome. Last call for questions before we
Okay, fine, I'm
say
gonna ask my
anything.
question.
Okay, go ahead.
I just had a phone call, anyway, I had a phone call at some point where a lady has a problem with the home, the care for her dad. And when she went to visit, one day, her father was walking in the hallway naked, right? And she just thought that, I mean, she completely freaked out. She said, I provided a robe. Why didn't they put the robe on him? He didn't want the robe. And I noticed that you mentioned that, you know, for example, like for the child, you decide what they wear, et cetera, et cetera. So now that I've personally had that come up, because I think we use that also in our volunteer training. If they don't want to, you know, I know that people have the right, but if they have guardian, I mean, you can't physically make them, but.
So, I mean, the tug of war slide, that's
Yeah.
between providers and guardians all the time.
And that's just on a case by case basis, right?
It is, and my first question would be, did he want the robe?
Right, exactly. And that's
And-
when I actually said, well, as soon as I asked, he put it on. I thought,
Yeah.
well, We don't
And then
know what
the
the
minute she walks up to the
situation's
door,
for.
they could take it off. So the second question would be like, hey, you have this robe, and if the caregiver says, well, we put it on him or we offer it, says no. And that, I mean, that's, I hear that all the time. I want mom to be more active. I want them to wear this, right? And then, but it puts the caregivers in a tough spot because these people are not cooperative with what it is that the guardian wants. But it's case by case, because on the flip side, there could be a caregiver that's not following any of the things that the guardian put in place, and all those things are actually good things that could prevent something. So
The other consideration though is if he's not following, if the house rule is to remain covered to some level of decency and it's causing an uproar with the other residents,
Right.
eventually you can get an eviction notice for that very thing.
Yeah,
So-
so it kind of went around that,
Yeah.
and I just want to make sure it's kind of steer people, and I was like, oh, that tell her wrong, she is the guardian. But it is, you're right, I mean, I can see where it's that fine line.
we all have the right to walk naked in our home. And these assisted living homes are meant to be
Best thing ever,
their
just
home.
kidding.
Yeah. Well, no judgment. I'll be honest. I walk naked in my home because I forget something. I mean, it's too chilly.
I have too many
Do it all the
security
time.
cameras in my home. I will not walk naked in my home.
Oh, I should be mindful of my Xbox.
Yeah, Alexa knows everything.
You know, the week where we hit 90 degrees. I mean, I never sleep naked, but we were sleeping naked with no covers because it was so hot. But this is his home, and if he's walking naked because he wants to, I mean, does he recognize he's naked, and does he mind having clothes on? It might be that he doesn't recognize his nakedness and doesn't mind having clothes, but those are the questions to ask. It's not like, oh, everyone needs to be dressed. That is the struggle and the tug of war and projecting your own ideals. You know, if you were to ask her, like, and of course, this is probably not something you can ask, but as a court visitor, I get to ask these questions, and I will say to her, if you're the guardian, do you walk naked in your home? Are you allowed to walk naked in your home? Because I can challenge that from a court level, where it may be more difficult as a volunteer to do that, but those are the types of things that need to get people remembering that if this is his home and he wants to be naked and there's no rule with the home that says he can't, then let the guy be naked. Now, if there is a female resident in the home, you also, and unfortunately, have to be mindful of the other people in the home. But if they could care less, then there's no problem. But
He'd certainly be naked in his own room.
Yeah,
If he had a
absolutely.
private room and he wanted to remain
if you
unclothed
want to be
there.
naked there, yeah.
Sarah did a home visit with a guy who was like in the buff the whole time she visited with him.
I had, as a care coordinator, I had male clients that did just, you know, I mean, I remember one going, Lisa, take a look at this. And he whipped over and he put his butt in the air. I'm like,
Yeah.
what am I looking at? You know, do I got a sore right there? I'm like, oh, okay, what? Yeah, you do.
Yeah.
You know, but you know, everyone's modesty is a little bit different. I've done training on, you know, I went to a couple of pioneer homes and did training on, you know, sexual expression between residents, and you always had that one staff person that was like, whatever, do whatever they want, this is their life, and then the one person's very, like, makes me very nervous, I don't like it, because we all have our own cultural views, our religious views, we have our own ideals, and we shouldn't be subject really to just another person. But you start with, this is the only life that they get, how can we make it the best life possible, and then you go from there. You know, if the best life possible for the person who wants to eat the entire bag of Snickers bars ends up in the hospital every single time and they don't want to be there. They can say, I don't want to go to the hospital, I don't want to be sick. But they can't take that and connect it to, don't eat the bag of Snickers bars. But you start with, what does this person really want? And then you go out from there and figure out if there can be any balance between the rules of the home, what the guardian wants, what the person wants. But you start with the person and their wants.
I think too is the role as the ombudsman. We're there to hear what they have to say, but on the resident roster, it's real nice to see that whether they have a guardian or not. If they have a guardian, I'm always going to listen, but you got to kind of process that ultimately it's probably going to come up to the guardian's decision as to make that decision. So.
Yeah, when our visitors, our volunteers go out to do visits, they always have a census list with legal representative names and guardians if there are any in place. And we try to touch base with them periodically, but not every visit, but once or twice a year.
Yeah.
You know, just to check in. Do you have any issues, any concerns? No, but thank you, Lisa. Tracy, Shannon, and Mary, if you don't have any questions, Mary's left. If no questions, we're gonna say goodbye to Lisa.
Thank you
Thank
for
you,
having me.
Lisa. I'm gonna turn the recording off. Maybe you've got that question you want to ask off record.